Hi drivers, I want to talk to you today about something that at least initially is going to sound like it's over your head, and that is the STAA's Reasonable Apprehension Clause. The STAA is an employee protection statute for drivers, and the statute covers, within the meaning of an employee, an independent contractor when personally operating a vehicle. So it would apply to an owner-operator or those so-called 1099 employees, which don't really exist. But if somebody's calling you an independent contractor, but you're driving their truck through some sort of contractual relationship. So the STAA is an employee protection statute applicable to people working in trucking, and it contains two classes of protections where a driver refuses to drive. One is where the driver refuses to drive because driving would result in an actual violation of a commercial vehicle safety regulation. Large or small, major or not major, a windshield wiper not working on a sunny day is still a required item, and a refusal to drive in violation of any commercial vehicle safety regulation is protected. Now there's a secondary clause that applies, and that's where perhaps you don't know whether there's an actual violation or not, or whether something is sufficiently serious, and that is the Reasonable Apprehension Clause. So the Reasonable Apprehension Clause of the STAA says that a employer, trucking company, private fleet, or a management employee of an employer cannot or is prohibited from discharging, discriminating against, or disciplining a driver who refuses to drive based upon a reasonable apprehension of serious injury to the driver himself or a member of the public because of the vehicle's unsafe condition. Now, when you're talking about a vehicle's unsafe condition, normally you would be thinking, well, maybe you hear a nasty noise, perhaps a loud whistling sound at the turbo of a vehicle or something of that nature, and you don't really know what it is. Or it could be something you do know what it is. But if your apprehension of serious injury because of the vehicle's unsafe condition is reasonable, objectively reasonable and subjectively, objectively means another driver with your experience and training would find this to present a serious safety issue, a reasonable danger to the driver himself or a member of the public, then you're protected. Now, in the context of bad weather or fatigue, you would normally not think that that could fall under the Reasonable Apprehension Clause. In other words, let's say you are refusing to drive due to bad weather, or bad weather that you foresee 40 miles down the road. Yes, there is a bad weather rule in the commercial vehicle safety regulations, which says essentially 49 CFR 392.14, which says when conditions become sufficiently dangerous, operations should cease. Now that's going to protect you, but who wants to necessarily be out there once it becomes sufficiently dangerous? Of course, you could be at home and watching weather reports, weather forecasts. But what is protected is not only those situations where an actual violation of the bad weather rule would occur, but those situations where the driver has a reasonable apprehension of serious injury to himself or a member of the public because of the vehicle's unsafe condition. The Department of Labor, where these cases are litigated, held many years ago in a case called EASH, E-A-S-H versus Roadway Express. The Department of Labor case number is 2000 STAA 47. I tried the case when I was much, much younger. But in that case, the Department of Labor said bad weather-related refusals can be protected where the vehicle is unsafe and the driver has a reasonable apprehension of an unsafe condition because the vehicle is rendered unsafe due to the weather, the roads, the slippery conditions. The same would apply in a fatigue-related refusal. But getting back to just bad weather, in the case of Esh was 22 miles, lived about 22 miles from the terminal, and in refusing work, he was looking at weather reports, television reports, the kinds of things you want to do before you refuse to drive based on weather and seek possible relief under the STAA. You know, he was looking, he was watching the news. But the judge in that case said, well, Mr. Esh failed to prove that an actual violation of a commercial vehicle safety regulation would have occurred but for his refusal to drive. He didn't rule for Mr. Esh on that grounds. What he found, though, was that the reasonable apprehension clause of the STAA, which prohibits retaliation because the driver refuses to drive because of a reasonable apprehension of serious injury to himself or members of the public because of the vehicle's unsafe condition, that applies in a situation where the driver reasonably believes, because he had an objective, court still has to find that the driver objectively believed that the driving would be unsafe. So he found that, one, Mr. Esh had an objectively reasonable apprehension of serious injury because of the weather, serious injury to himself or members of the public because the vehicle's unsafe condition rendered as such by the weather. And two, and this is important, if you're going to refuse to drive, it's important that you seek, at least in the case of when relying upon this reasonable apprehension clause, it's important that you seek, the statute requires this, for you to be protected, that you seek and be unable to obtain correction of the unsafe condition. In this case, dealing with bad weather, the judge found that when Esh booked off, called in, booked off work, he saw it and was unable to obtain correction of the unsafe condition. If you watch this and are still completely confused, let us know in the comments section below and I will redo it. Thanks for watching.